everybody, it's attorney Ashley Goggins here with Ashley Goggins Law. I'm coming to you once again on a Friday for Free Game Friday. Go ahead and share this out with any fathers that you may know. They may need this information, and I am going to go ahead and do the same. Thank you for all of my returning viewers. Thank you for everybody that watches every single week and tunes in live as well as the replay, because I know some of you all may be at work. So let me just share this out. All right, we are posted. Let's see. All right, y'all. We are gonna get this thing started. So our question for today is about basically child support modification. This father submitted a question online at www.freegamefriday.com. Listen, if you want your questions answered each week live right here, make sure you go to www.freegamefriday.com and make sure that you are getting your questions answered, okay? So if you do have any questions that you want me to answer live today, go ahead and put them out in the comments. And again, if you're just coming on, share this out with everybody that you know, fathers included. Hey there, hey there. Okay, so let me make sure I don't have no lipstick on my teeth, y'all. Okay, so the question, let me make sure I got my question. I'm reading it correctly. So this question says, my child is 18 but still in high school. Can I terminate or modify child support? Hey girl, thank you for coming on. So this father wants to modify child support. So it really depends on when the order was created. But typically once your child reaches the age of majority, meaning they turn 18, the child support should be modified or terminated. So there are a lot of times when a child may be still in high school and they may turn 19 years old. Although, you know, technically if you're still in high school, you may be a minor, the law basically states that if the child dies, if the child reaches the age of majority, if the child gets married or no longer needs the support, the child support can be modified. So yes, you do have grounds for modification if the child has reached the age of majority, because the statute says whatever happens first, okay? Whatever happens first, either he or she reaches the age of majority, she gets married, what else is the other one? Becomes self-supporting. So she may become self-supporting on her own. The law says whichever comes first. So you do have grounds to terminate. Now, on that same token, I know a lot of people message me and ask me about child support modifications. Now, you cannot modify, even if the child turns 18 years old, that does not mean that you no longer have any financial obligation to pay. That just means that your current ongoing child support, you no longer have to pay once it's modified. But your back pay or your arrearage will still be in place if you have not paid all of your back pay, all of your arrearage. What about if they proceed to college? I heard that if it can go into the completing of college. Well, it can go into completing of college if that is what they agreed to in terms of a marital settlement agreement. So sometimes that's negotiated if if the parties were married and they actually negotiated that in the actual order of negotiation. If the father or mother wants to modify it after they've already agreed to it, then there's going to be a higher standard and a higher burden to get that modified. A lot of times fathers are paying up until college because they have back pay. They have arrearage that they're still paying on, which is why they end up paying till 21, 22, 24 years old, because they have that arrearage that's tacked on to it. So I think that it's not necessarily a situation where they still are paying actual monthly child support. I think a lot of the times it's back pay. But what I will tell you is that when two parties were married, a lot of people, especially nowadays, are negotiating that in the marital settlement agreement at the end of the marriage and once it's over. Anybody else have any questions? We can talk briefly about modifications for child support when there is finances. A lot of times one party may start making a lot more than the other party, or the other party loses a job or no longer is employed, or what we like to call underemployed. If that happens during the child's age of minority, meaning under 18, then those are grounds for a modification. Now, I'm going to tell you, just because one party incomes increase, that alone is not a substantial change in circumstances that will warrant your child support increasing or decreasing, okay? Either way, okay? So be careful about just wanting to get a child support increase because the other party's income has increased, because that alone is not going to be enough. Now, on the contrary, if someone no longer has this type of income that they had when they actually entered into the agreement or were placed on child support, then that's grounds for a modification. So you lost your job, you're underemployed, you used to make $30, $20 an hour, but now you're making minimum wage and you can no longer afford your payments. So basically your child support should not be, over 50% of your income. And if you're at a point where you're paying more child support and you can barely live, then you might want to think about getting a modification if that is you. What else do I have written down here? Basically, the biggest thing is make sure that there's some type of substantial change in circumstances. Like you lost your job, you've been actively looking for employment, you are sick, you may be disabled, your job type may have ended, you may be going back to school, things like that. You have to be careful because judges are going to look at whether you are voluntarily underemployed. So if you're out there and you're not employed but you can work, then income can be imputed to you. Imputed means, okay, if you were to be working, you would be probably worth this, okay? Especially if you've had a job history in the past, what we do is we average out your income. So if you made $20 at this job, $10 at this job, and your last job you made, $15. The average between those three jobs would be what we could impute as your hourly rate on your job, if that makes sense. Does anybody have any questions about child support modifications? Again, retroactive or back pay child support is generally not able to be modified unless there are certain circumstances that warrant the modification. We are talking specifically today about modification based on the termination of need. That means age of majority, there's a death. Now, if the child has a disability, and that disability is still in place after 18 years old, then the parent is still responsible to pay child support and could possibly be paying child support for the life of the child if the other parent or whichever parent is paying has the ability to do so. So if your child has some type of illness, then you will be required to pay over the age of majority. So as the child reaches 18, they marry, they become self-supporting or die, whichever comes first. So to answer the question that was submitted, yes, you can get a modification because now the child has reached the age of majority, regardless if the child is in high school or not. Okay, so again, guys, share this out with anybody that you may know. Make sure that if you have questions about anything related to fathers, you go at our family law for that matter, because we are wrapping up our Father's Rights edition for October, because I believe this is the last Friday in October. And what a way to end it with child support modification, okay? Now, this is the last thing. When it comes to child support modification, if you are in the red, meaning you have not been paying yourself, you are literally in the negative when it comes to paying your child support, or your support payments are delinquent, you have something called unclean hands. That means that you are requesting to have this modification done and you haven't even met your current obligation in terms of what you were supposed to be paying. So be careful about having the unclean hands. So if it's in terms of arrears, or if it's in terms of back pay when you were unable to pay and you actually showed that you did not have the ability to pay back then, as long as that still stands, you're fine. But you need to be current when you are going before the court on modifications, or you're going before the court asking for a substantial change in circumstances. And that's something that with speaking to an attorney, you can kind of see. If you can anticipate those changes about to occur, you probably want to consult with an attorney about how to best make your moves. And I know this is Father's Edition, but if it's any ladies out there, ladies, there are some times where you don't know what to do because maybe the father does not have a job. Maybe he's working, but he's not working compared to the IRS, or it's not documentable. I just made up a word. You can't document the employment. So if that happens, we can still impute income. We still can impute income as long as they don't have a disability, and if they have a disability, they need to be getting a disability check. And that goes for both sides, okay? Because someone can be underemployed. Are they voluntarily underemployed? Because why aren't they working? Why aren't they out there getting a job? If they work under the table, then we could impute minimum wage. If the person did go to college, we can factor in someone that has a college degree may make more than minimum wage having a college degree. So that's some things that can work with. You got to be real creative in terms of that. Anybody got any questions about modifications, child support, increased need, anything like that? Also, I keep saying also, but increase in need in terms of even if one party is making more than the other party, if there has to be an increase in need for the child. So fathers, even if you are making more, that doesn't necessarily mean that when your child's mother goes to ask for an increase, it'll automatically get granted, because there may not be an increased need in the child. Their lifestyle may not have changed just because your salary went up. Can I still collect child support even if the child doesn't live with me? No. What do you mean? Like, majority of the time you're getting child support because you're taking care of the child, or you have the majority time sharing with the child. Now, if the child is in college and there's still back pay going on, or some type of arrears, or there's an agreement that you will receive child support payments and the child is A, B, or C, then that's up to the father. I'm the custodial parent, but the child lives with their dad. Well, if I'm going to tell you hypothetically, I would be telling the father that he should be getting a modification of his child support, because child support is based on the time each child spends with each parent and the finances of each parent. So there are certain circumstances where it could be in the middle because the father may make substantially more. But if he's with the father more than you, then likely his child support would be decreasing. And I would tell him that it's time for a modification. That's what I would tell him. So you can take with that as you choose. The devil's advocate way. But each circumstance is different, and there's probably more facts to that, I'm sure. But if he's still paying back pay, that is a vested right. So any type of back pay is a vested right. So nothing really can change that vested right. And I keep saying back pay, retroactive pay, it can go back 2 years. So it used to be back into the child's age of birth, but now it is back 2 years of child support arrears or back pay. Any other questions? Well, that was fun. If you guys have any questions, be sure to be back here next Friday for whatever question we choose. If you want questions answered here, or any questions, because sometimes I'll answer them on Facebook Live, you can submit them at www.freedomfriday. I'm talking about Freedom Friday, y'all. I'm tired. freegamefriday.com. Will I get in trouble if I don't report the fact that they live with you? You won't necessarily get in trouble. Like, that's what I'm saying. Like, you won't get in trouble because no one will know unless he has to file some type of paperwork for a modification based on that. But no, you won't get in trouble. Not at all. No, you will not get in trouble. Unless you're reporting somewhere that they stay with you, honestly. But you won't get in trouble. Not in terms of child support. I have to be very clear about how I answer questions. No, not in terms of child support. Any other questions before I hop off, guys? If you do have any questions, you can ask them in the comment section and I'll be around to answer them in text format. Again, make sure you share this out with any fathers if you are watching this live. And if you are watching on the replay, go ahead and send it out. If you need a lawyer for any family law,